Welcome to another edition of the PSRB LAWCAST from the offices of Pellegrini, Seeley, Ryan, and Blakesley. I'm your host, Adam Wright, and each episode we bring you information about the various aspects of personal injury law. We understand that approaching a law firm to help you can be intimidating. And so that's why this podcast is designed to make personal injury law just a little bit easier to understand and to help you navigate the process with greater comfort. Remember, every case is different, and in order for us to provide you with accurate information and advice relevant to your specific circumstances, it's really important to set up an appointment with one of our attorneys to meet in person, and the information presented today is just for general information purposes only. Today we're going to be discussing various aspects of Social Security law, and to help break it down for us is PSRB Attorney Dan Blakesley. Dan's an associate with the firm, and the focus of his practice is within the various areas of personal injury law. In addition to advocating for injured workers before the Department of Industrial Accidents, Attorney Blakesley also represents clients who have been injured through medical malpractice, in car accidents, and slip and fall accidents. Prior to joining the firm, Dan spent 10 years working as a claims adjuster for a major Massachusetts workers' compensation insurer. And that experience gives him some pretty valuable insight into the reasoning behind insurers' methodologies and valuations of claims. He's a great negotiator, an implacable advocate. Dan Blakesley, how you doing?
I'm good, Adam. How are you?
Great. Now, today we're going to be discussing Social Security. And I know that most people, when they think about Social Security, they think about something you collect when you turn 65 or 67. But in fact, if you're seriously injured, Social Security is something you can avail yourselves of no matter how old you are. So I think it's probably best to start with an overview of talking about what it takes to collect Social Security and who is qualified to get Social Security.
Sure. And there are several different criteria that we can go over here. I think first, it's important to note the economic criteria. And when I say economic criteria, I mean that people can get Social Security disability benefits if they have enough work credits. That's basically they've earned enough money over the course of their careers in order to qualify for benefits based on what they've earned. Typically, the average age adult needs 40 work credits to qualify. You can earn up to 4 credits in a year. It's about $1,500 gets you 1 credit, and you can earn up to 4 in a year. So if you've earned $6,000 in 2022, you've earned 4 work credits. 20 of those credits have to be in the last 10 years, and this differs by age. But all that to say that if you want to get benefits based on your actual earnings, you need to have enough work credits.
And is that benefit based on the amount that you've earned, or does everybody get the same thing?
No, that's based on what you've earned. There is a formula that they apply to determine what your monthly benefit rate would be based on your past earnings.
So let's say if you're injured at work, maybe a very serious injury. You've got your arm caught in a machine. You can't work again, doing really any job maybe, and you apply for Social Security. This is to help you permanently, financially.
Correct. It's always a good idea, particularly with catastrophic injuries such as the one you're describing, to get on Social Security disability for a number of reasons. There's no time limit on the benefits like there would be in many comp cases. If you settle your workers' comp case, any offset to your Social Security benefits would be reduced or go away completely, which would cause your benefits to be maximized, and you'd have ongoing income after a settlement. So in many workers' compensation cases, we recommend and help people apply for Social Security disability.
So it's really a safety net that helps you because you can no longer work.
Correct.
So you have to have at least 40 credits.
Correct.
And those are determined by the amount of money that you've made in the past year?
Correct. Each calendar year, you can earn up to 4. And the amount of money it takes to earn a credit changes by year. It's tied to inflation. Those who do not have enough credits can still get benefits, but there's a distinction. SSDI Social Security disability insurance is based on your actual income, and that's the benefit that you get if you have enough credits. Those who do not have enough credits still qualify for SSI, which stands for Supplemental Security Income. That is a set monthly amount. That is what's called needs-based, which means any assets that you have can count against that and reduce the benefit. So if you don't have enough economic credits, you still may be qualified for benefits, but you may not get nearly as much as those who would qualify and have enough work credits to get the SSDI benefit.
So if you let's say have a injury, but you don't have enough work credits, but you have significant money in the bank, they'll credit that against what you would get for SSI.
Correct. Significant money in the bank. If you own a car, if you own a home, those are all things that could potentially disqualify you or significantly reduce your monthly benefit amount.
And would that mean that somebody would potentially have to sell their car or sell their home in order to qualify?
I mean, I've never recommended that.
Right.
Because that could put you in even a worse position than you'd be in otherwise. If you did sell your car or sell your home after they made a determination that you didn't qualify, it would certainly be something you'd want them to look at again.
Because I think it'd be easy to be house poor. Let's say you have a catastrophic injury. You own a home. Let's say just for numbers' sake, your home is worth $200,000, but you still have a mortgage outstanding, even though you have equity built up in your home, but you can't work. How do you then get enough money to sustain your mortgage?
It can be difficult if there's especially if there's no underlying workers' compensation claim or something else. We do see situations from time to time where the facts of a particular case line up in a way that leads somebody to a situation where they have no recourse. There's no benefits because they don't qualify because they own a little bit too many assets, but they're still poor and still in need of benefits, and they don't have that. So, I mean, we could certainly look at every case as they come in, but the economic criteria for SSDI, they're pretty rigid, and sometimes they disqualify the people that need the benefits the most.
Well, it sounds like it's a potentially frustrating situation, and even more reason to get some specific information regarding your case from a qualified Social Security attorney.
Absolutely.
So how does the application work? You've now been injured, and you believe you're in need of Social Security. What is involved with applying for it?
There are two basic ways to apply, one of which I recommend, one of which I do not. Now, pre-pandemic, you could make an appointment and sit down with a representative at your local Social Security office to complete an application. That process is still available, but for now it's being done telephonically. They're starting to do in-person hearings again, and that may change, but we strongly recommend applicants to actually complete the application with a Social Security representative. You want to make sure that the right boxes are checked. There are a number of things that are traps for the unwary, for those who decide to do their own application. I had a gentleman who had somebody else do the application for him, not a representative of Social Security. The case was later transferred to me. This person got all the way to a hearing in front of a judge, and they checked the wrong box on his application. They checked a box that they checked that he was applying for SSDI, which would mean he'd need to prove that he became disabled 15 years prior to the hearing date, and there were no medical records to support that. The box that should have been checked was the SSI box. You'd think a judge would be able to just make a quick note of that and then conduct a hearing. They made this gentleman start over and do a new application. So you can do your own application. You can do it online. I do not recommend it. It's
too many things can go wrong.
Absolutely. Yeah. And that case was a good example of that.
So you've done your application telephonically. What happens then?
You're going to hear from Social Security within a few months, typically. It's been taking longer in 2022, we've seen it take a little bit longer. It's more like 5-6 months, but you will get a determination from them. And it's either going to be a letter saying we've approved the application, which is rare, or it's going to be a denial. Denial will specify that you have 60 days to appeal. That's when you really want to pick up the phone and get a lawyer involved.
Would you say that the majority of them get denied right out of the box? Is this a standard operating procedure?
Yeah. The vast majority of cases get denied on the first application.
And is this is a federal or state benefit?
It's a federal benefit.
So a federal bureaucrat is making the decision as to whether or not you get your money.
Right. And what they're supposed to do is get the application, request medical records from the providers you've been treating with for any disabling conditions, review those records, and make a determination. I've long suspected that many of these people don't give these cases much of an in-depth look. They may even stop at the age and deny the application. And if it gets denied once, it's probably going to get denied a second time, at which point you're headed towards a hearing with an administrative judge.
And if it gets to that point with the hearing, is that something that you have a lawyer with you to facilitate, or do you do that on your own?
No, you should. You could do the hearing on your own. It would be a difficult thing to do. You really want a practitioner who knows the ins and outs of the law, knows what the judges look for in approving or denying an application, someone who knows each particular judge in your area, so you know their tendencies and the way, what evidence
what they're looking for.
Yeah. Exactly.
And typically, is there sort of a path of what they're looking for? Is that something that's different for each case, or is it more universal?
The answer is both. The criteria, in terms of proving that you have a disability that entitles you to benefits, you need to show that you're incapable of what's called substantial gainful activity, which is a fancy term that basically means you can't do any full-time work. Everybody's different in terms of their age, their work background, their education. Social Security looks to all that. But they also look to whether or not you can do any full-time work in the open labor market. If you were a construction worker making $2,500 a week, but could be employed full-time as a Walmart greeter, you're not entitled to benefits.
Does it have to be any position that you can do, or does it have to be something in your field?
It doesn't have to be something in your field. If you're capable of full-time minimum wage work at a simple job, as long as you can do that job, then you're not qualified for benefits.
I think that's an important thing for people to understand.
Sure, and it can make the application very difficult. One of the things we look at, and a good reason to have a lawyer, is you need to be able to convince these judges somehow that you're not going to be regularly relied upon to report to work. And there are a couple of ways to do that. A lot of our clients have injuries that would allow them to work a simple job for an 8-hour day on a good day, but they have many bad days per month, or at least a few bad days per month, which would force them to call in sick for work. Likewise, some of our clients, many of our clients, have injuries that would allow them to perform 8 hours of work in a day with frequent breaks. If Social Security finds that you are incapable of showing up to work more than a few times per month, or finds that you'd be off task for 15% or more of a workday, you're not qualified. But you're not going to be relied upon. No employer can rely on you for any job.
Not qualified to work.
Correct. Now, if you're not able to regularly report for work or able to stay on task at work, no employer will keep you on their payroll.
And so an attorney would be a good advocate in helping the judge understand just how injured you are.
Right. And we craft questions that our clients answer during testimony that highlights those things.
So let's talk about that. What happens during a hearing?
Well, you go into a courtroom, if it's in person, which they're starting to open up again, and only the people that need to be in the courtroom are there. It's not like there's a gallery of people waiting for their cases to be called. We get a lot of questions from our clients about that. In the hearing room will be the judge, a court reporter, a vocational expert, and the Social Security claimant and his or her attorney. The judge will open the hearing by reading off some procedural things that need to be read off. She will ask questions of the applicant which include questions about work background, education background, diagnoses that are the basis of the disability, and sometimes disability itself, the type of issues or symptoms that are preventing the person from working. At a certain point, depending on the judge, it's turned over to the claimant's lawyer to continue with the questioning. And that's when we really want to focus on asking questions that are going to highlight the specific areas that are going to be problematic for the person in trying to work.
What then is the job of the vocational expert?
The vocational expert is asked questions by the judge. The judge will ask hypothetical questions about an individual that might fit the claimant's profile in terms of the restrictions they might have if they were to try to work. The vocational expert will testify as to whether that hypothetical individual can perform either past work or any work available in the national economy.
And what happens if the judge approves the claimant's petition?
Well, then you get a series of letters that tell you exactly what the benefits are going to be. And then at a certain point, the checks start. Most people would receive a retroactive check for whatever benefits were due from the date they became disabled to the date the case was decided. And then monthly checks would start arriving after that.
And how long typically does it take to get your first check?
It really varies. We've had clients that got their first check before the decision came in the mail, and they call us asking what it's about. We had clients wait over 6 months after the decision for their first check. There's no rhyme or reason to it, but once you get a favorable decision, you at least have the peace of mind of knowing you've proven your case and that you're going to be getting benefits.
Does the judge decide on the spot whether or not the hearing is successful for the claimant, or does it take a period of time?
In rare cases, they will announce their decision from the bench. Most of the time, they do not. Most of the time, they'll just say that they'll look at all the evidence and send out a decision. In some cases, there are cues that the savvy practitioner can pick up on and know that the application is going to be approved as well without the judge saying as much. But in the vast majority of cases, you don't know until you actually receive the decision in the mail what the judge has decided.
And how long typically does that take?
Depending on the judge, they will tell you it's usually 2 months. Most judges are around that timeline, but some of the slower ones can take up to a year.
And conversely, what happens if the claimant's petition is denied? Is there an appeals process?
There is. It's not a great one. In order to appeal a Social Security hearing denial, the claimant must make a petition to the appeals council. This is a written brief, for lack of a better word, that has to make the argument that the judge was erroneous in his or her decision by misapplying the law, or that there was evidence of bias or something like that. There are very narrow reasons for a hearing decision to be overturned. It cannot simply be that you feel the evidence supported that the person was disabled. That is within the judge's discretion to find, and disagreeing with a judge on something like that is not grounds for an appeal. If a claim is appealed, there's a significant wait. The appeals council typically takes a year to a year and a half to respond. Most of the time, they will issue a denial. If they agree with you that the judge was erroneous, they send the case back on remand for a new hearing, which typically results in the claimant having to do a new hearing in front of the same judge. The problem with that is the judge is already upset that his decision has been overturned and is probably likely to make the same finding with a stronger decision that is less subject to appeal.
What is the attorney's role in all of this at the hearing and throughout the whole process?
Well, when we first do an intake on a Social Security case, we have to determine what the disabling conditions are and whether or not they rise to the level of preventing somebody from working any full-time job. But sometimes we decline to take the case on at that point. There's a lot that goes into representing Social Security claimants, and we want to be sure that we're being a bit selective in that because it's only a small part of what we do here. We like to try and help people, but there are some cases where there's just no chance of the person getting on. Once we take the case in, what we'll do is we'll send paperwork that we're representing the person and help them through the process. There are 1 or 2 appeals that get done. If there are 2 appeals, there'll be a hearing. Once the hearing gets scheduled, we gather all of the medical records, which is important to do because otherwise you're trusting Social Security to gather all the medical records, and they can't be trusted to get every piece of evidence that might be supportive into the record. And then we do a full prep before the hearing. We typically bring the client in and explain the hearing process. And then I personally go through a series of hearing questions with the person. And it's as much for my benefit as theirs. It gets them ready for the hearing, gives them an idea of what to expect. It also helps me develop a roadmap of where I want to go with my questions in the hearing and keys me into the areas I need to really focus on to give the claimant a best possible chance of getting on.
For those who are listening to this podcast who may not be in our area, what kind of attorney should they look for? What kind of experience should they look for? Is it something that any attorney can do? Do you have to be an attorney to represent somebody in a Social Security case? How do people go about judging whether or not someone is qualified to represent them?
Well, you do not have to be an attorney to represent somebody applying for Social Security disability. I think I would strongly recommend that you not only hire an attorney, but you hire somebody that's local, that does a fair amount of Social Security hearings and knows the process and knows the law.
And knows the judges, I would think.
Correct. Yeah, it's important to know not only just the judges, but the people at the hearings office. Those familiar with the inner workings of each office tend to have an advantage.
I hear ads on the radio sometimes for these nationwide firms that handle Social Security claims for people. Are those reputable?
Yes and no. It's hard to tell which ones are and which ones are not. Again, if you're using a nationwide firm, you lose the benefit of having a local
being that local,
practitioner.
right?
But I've seen a number of real red flags with these places. I had a client come to see me, walked into our office on the day of her hearing in tears because she had signed up with one of these firms. Now, after she signed up with this firm, she didn't hear from anybody. When she had to do her appeal, she called them. They did the appeal without asking her any questions, just put an appeal in for her. When the hearing came up, she was calling, waiting for somebody to be in touch to prepare her for the hearing. Nobody called. She showed up to the hearing in a panic, and no representative from this company was there. And the judge mercifully continued the hearing to allow her time to find effective representation. But these companies might not always be what they say they are. And I think it's important to try and get a recommendation from another attorney or from someone you trust for local representation with a practiced attorney who handles a lot of Social Security.
Is the local bar association a good place to get a referral from?
Definitely.
Yeah.
Definitely. We're signed up there, as are a number of practitioners. The local bar association will be able to identify those attorneys that are best suited to handle cases like this.
One question I had, can you work part-time when you're collecting Social Security?
Sure. Yeah, you can. And there are two basic ways that you can go about trying to work. Social Security has it's called a Ticket to Work program that allows people receiving benefits to try and return to work without putting those benefits in jeopardy. You get a grace period of 5 months where you can earn as much as you're able to earn without affecting your right to receive benefits. That's Social Security giving people motivation to try and get back on their feet and get off of benefits if they're able to. In addition to that, you can receive Social Security benefits and still have a part-time job, theoretically without affecting your right to those benefits. In 2021, I believe the earning limit was around $2,100 per month. I will caution you, though, I have had cases where Social Security has seen that people are making money, and it does trigger them to take a harder look at the person's case and maybe reevaluate their entitlement to benefits, even if they're earning below the limit.
How does the fee structure work? Does it cost the applicant money to hire an attorney?
The attorney is only paid if they're successful, as is the case with many other types of cases that we handle.
Personal injury law, right.
Sure. The way that it works is that if there is a favorable decision, either fully favorable or partially favorable, and there is an award of back benefits, retroactive benefits, the attorney fee is 25% of those back benefits, capped at a maximum of $6,000.
And clearly, I would think there would be back benefits since this process takes so long.
Sure. I mean, it really depends. If somebody has a catastrophic injury, often they'll apply right away. If they get on after a year, there might only be a limited period of back benefits. There is a 5-month waiting period. So the date that you became disabled is when the clock starts ticking. Then after 5 months expire from that date, that's when you are entitled to start receiving benefits. So in some of these cases, the retroactive benefits period is very small and the attorney fee is small. None of us who practice this here focus on that when we're deciding whether or not to take a case. But sometimes it could be a number of years between the time the person went out of work and the time they're put on benefits, and the fee ends up being the maximum $6,000 fee. Really depends on each case.
Yeah. Well, this has been a really illuminating conversation, and I'm sure that there's information here that will definitely help people. Dan Blakesley from PSRB. If somebody wants to get a hold of you, they can do so at psrblaw.com, or of course, our phone number at 800-785-5399. Thanks so much for stopping by and helping us out with this information.
Thanks for having me, Adam. It's been a pleasure.